homeowner's choice. Mr. Herman, are you going to reserve 5 minutes?
Yes, please.
Okay, go ahead, sir, please.
All right, good morning. I'm Jason Herman, and I represent Synergy Contracting Group. Dismissal for fraud in the court is the most extreme remedy that should be reserved for the most extreme cases. Situations where fraud in the court dismissals are appropriate are rare. And they're the kind of thing that cause lawyers to have conversations that start like this. Can you believe what this plaintiff did in my case? Extreme cases aren't the kind of cases that are met with PCAs because the behavior is so extreme and so bad that courts at every level want to call out this behavior.
Well, Mr. Herman, let me ask you a question, because as I understand this, this basically is an insurance claim due to a broken pipe or water damage. And as I understand it, that the homeowners, not to be confused with the insurance company, which goes by the same name, basically said, hey, if we're going to go ahead and repair this water damage, we might as well upgrade our kitchen. And we realized we're going to pay for that extra upgrade. And so they did that. These repairs were made. I believe about $19,000 worth of bills were submitted to the insurance company, which the insurance company paid. About $17,500 worth of bills were submitted elsewhere, not to the insurance company, to make these upgrades that the homeowners wanted. So at the end of this, your client submitted a bill for additional payment over and above the $19,000, all of which included either some of these upgrades which were otherwise paid for or work that was never done. So as I read this, and this is the part I want you to help me with, 100% of what your client was seeking, they were not entitled to. Is that correct?
Is it correct that they weren't entitled to anything at all? Is that the question?
Well, that's my question to you. From what my reading of this case, it looked like 100% of what they were asking for was either paid out of pocket to other providers who did the work, or they were asking for work that they never performed.
And so those were the two arguments that were made below and in the briefs. Let me address the upgrades first. So the insured here, the homeowner, did testify that he upgraded some items during repairs, and those were paid out of pocket. Now, those were upgrades, and so Synergy didn't take the position they were part of the claim or that they should be paid by homeowner's choice. Instead, Synergy only sought payment for the original base quality, for like, kind, and quality, and that's what's in the estimate. And that's the right thing to do on an insurance claim, because seeking payment for upgraded quality when that wasn't there at the time, that's wrong. That is, we're talking about fraud if that happens. But what's being claimed here is that Synergy can't collect for any of those items that the insured paid for. But well, first of all, that's not how the law works on an AOB case. So homeowner's choice doesn't get a set off for money paid to Synergy by the insured. Homeowner's choice owes Synergy whatever it would have owed its insured, because Synergy stands in the shoes of that insured. Now, if there's a double payment, that's an issue between the homeowner and Synergy. But more importantly, the documents and the testimony just don't clearly show that the homeowner was fully paying for those items when he paid for the upgrades. So the base cost of these items, so the original cost before they are upgraded, is something the insured believed the insurance company should pay for and not him. And he testified, the insured testified, he fully understood that the additional cost was on them, the homeowners, not the whole cost. And if you look at the change order and the estimate, the original estimate attached to the complaint, it really drives this home. So line items 49, I want to talk about the cabinets specifically in the kitchen. Those are at line items 49 through 52 of the estimate. And those relate to the cabinets. They add up to $8,100. Now, homeowner's choice says this was paid by the insured because the insured paid the upgraded cost. But if you look at the change order, this is at line 1, the cost of upgrading those cabinets, which included adding cabinets, adding a pantry that wasn't there before, adding a coffee nook that wasn't there before, was $4,250. So the interpretation advanced by Homeowners Choice is that upgrading and adding cabinets made the total cost come down from $8,000 to $4,000, and that the insured fully paid for all the cabinets when it only paid the $4,000. But the more reasonable interpretation of that is that upgrading and adding cabinets and adding a pantry and adding a coffee nook increased the price by $4,000, meaning the base price remained at $8,000, which should have been paid by the insurance company, but wasn't. And the upgraded cost was $12,000, and the additional $4,000 of which should have been paid for by the insured and shouldn't be claimed.
So is your position that your client made zero misrepresentations? That everything that your client was claiming was legitimate and fair game?
That's the position. Yes, Your Honor.
Okay. And Judge Ramsberger, I mean, reading his transcript, it looks like this was a pretty contentious ending to a hearing. I mean, it was, you don't see this kind of thing very often. He apparently strongly felt otherwise. Would you agree with that?
He felt otherwise. There was, you could read the tone in the.
Well, I mean, I felt like it was jumping off the page to me, but you're right. You can't read the tone. It just sounded ugly, didn't it?
Oh yeah, and it seemed to me that there was probably, well, it started off because there was a response that was filed at 10 o'clock at night the night before, and I think that got him off on the wrong foot, and it continued on. And of course, the way that hearing ended, it's not good at all. But yeah, and Judge Ramsberger quoted Cox when he made his findings, but we have to look at this as what did the facts actually show, and here when you look deeply at them, you're not seeing misrepresentations here. But also on top of that, misrepresentations by themselves are not sufficient to dismiss a case for fraud in the court.
Mr. Herman, can you address the owner's testimony that discusses that there wasn't any, I think it's packing of contents or packing up any items, and also that they declined to have any painting certain areas that weren't painted. And yet we see on the invoices that Synergy is seeking monies for that work.
So on the issue of the contents, there's the homeowner testifies that, the contents weren't handled by Synergy. That testimony comes after the interrogatory answers, in which there's an answer from Synergy that says Synergy did not handle contents. And so there's, this is not a scheme to hide facts. I mean, Synergy is saying outright.
Well, yeah, okay. So the answers come back, there weren't, yet they're on the invoices that are attached to the complaint. Was there any effort made to amend the complaint to remove those items?
There was no amendment to the complaint. There's a statement in the interrogatories that says these weren't handled. What that means, the record's unclear. I mean, we know just as a practical matter that when this kitchen was tore down to the studs, which is a testimony from the insured, and rebuilt with new cabinets, something happened with those cabinets, with the contents, whatever that would be. Whether they were put in boxes and not moved off site, whether the boxes were supplied, or whether this was done by a subcontractor. It's just silent on that issue. And so, but what we're looking for here is there a this scheme to hide facts, and the issue of contents, the testimony from the insured and the statement in the interrogatories are consistent with each other.
To what extent can we give well, here we have Synergy standing in the shoes of the owner, right? And so if the owner is testifying certain things are done, how do we weigh that against, you're saying, some of these answers to interrogatories by Synergy? So
the homeowner is a non-party, and he's a lay witness, doesn't have construction experience. He's testifying that he wasn't there for most of these repairs, and he's testifying 2+ years after they're done. And when you look at his testimony, there's times where he's saying, I'm not sure, I don't remember. He's got some things that internally conflict with each other. All totally normal stuff. But what it doesn't make sense when you're looking at fraud of the court to take the testimony of one witness who's a non-party and treat that as gospel and say that anything in written discovery that contradicts that testimony is fraud. And I want to circle back on this question Judge Morris raised. I think I didn't finish answering it on the issue of work wasn't done. So one of the examples in the answer brief on this, it's on page 16 of the brief, it talks about this $1,627 of work that the insured says wasn't done, but it's in the estimate. So if you look at the actual testimony there, the insured is testifying about line items 21 to 30 of the estimate. And when he's asked about what work is done, what he actually says is it's possible 21 through 27, but 28, 29, and 30 they didn't do, which means he's testified of that $1,600 worth of work, $1,445 of it possibly was done. And of course that means possibly wasn't, but possibly is not clear and convincing evidence. And by the way, the three things he says weren't done add up to $181. Possibly is speculation. It's not even admissible evidence, much less clear and convincing. But here, there's a lot of focus on what, were there misrepresentations? Were there things that were said that were inaccurate or wrong? And the discovery responses in the discovery responses and the estimate. There's a lot of other elements that have to be present to justify fraud in the court dismissals. You got to have intent by the party, a scheme that's carried out by the party. It's got to be calculated to interfere with the judicial system. It's got to unfairly hamper the presentation of the defense. And we don't have evidence on those things because there's no testimony from Synergy. There's no evidentiary hearing that takes place here. There's no deposition that takes place here of anyone other.
Just to interrupt you briefly, Mr. Herman, because that's a question that I had. Is one required? In other words, must there be an evidentiary hearing to support something like this?
So the law says it almost will always be required to develop the evidence. So it's legally not required to have an evidentiary hearing. So Judge Ramsberger didn't do something wrong by not having one. But what with the case law, and actually the Bologna case says it straight out, that to develop the evidence of a scheme, a calculated scheme, will, quote, almost always require an evidentiary hearing. And when I looked, there's just, I couldn't find any cases where you have evidence this light, where you essentially just have some interrogatory answers and requests for admission denials, which aren't even usable as impeachment material. And if you compare what is here to the cases that affirm dismissals for fraud in the court, one of the huge differences is those cases involve sworn testimony of the actual plaintiff, not just written discovery. And almost every case, like I said, involved.
Mr. Herman, was a request made for an evidentiary hearing at the hearing?
It was not. Neither party requested an evidentiary hearing.
Okay. And so the basis for, if you're saying we should reverse because an evidentiary hearing wasn't held, and how can we do that where that wasn't preserved below? So
that question was the very first question asked in the oral argument on the Duarte versus Safe Step case, because that case also did not have an objection made to the lack of evidentiary hearing. And this court reversed that case. And there's a reason for it, because an objection to this type of hearing going forward on a non-evidentiary standpoint isn't legally correct, because it is allowed to go forward. The case law doesn't say it's wrong to do this legally. It's just that the evidence that comes out in a case without one is almost never going to be sufficient to hit the elements. Because what happens, just like in this case, what's being asked for in discovery and in depositions and in written discovery is talking about the core issues in the case. Where the damage is, where the causation, things like that.
And if it were reversed and remanded for an evidentiary hearing, one of the things that that raised a concern for me was when the court asked Mr. Vargas whether or not he refuted any of the owner's deposition testimony. And I think the response to that was no, they weren't refuting that testimony, but they were just refuting, I guess, the characterization of his testimony. So what benefit would it be for us to remand it back for an evidentiary hearing then?
And you're at 15 minutes, Mr. Herman, so it's your time. Use it however you want to.
Appreciate that. So when I read that comment in the transcript, it looked like he was saying it's not that we disagree. He said what he said. It's how it's being interpreted, and that's the same thing in our brief, and the same thing I'm saying here today is that there are multiple ways you can interpret what he said. You know, paying for upgrades. You know, can you interpret as I paid for everything? I suppose you can, but I think there's also a very reasonable interpretation that you can't interpret it that way, and that can be solved very easily. You know, Mr. Homeowner, what do you mean when you say you paid for upgrades? Did you pay $12,000 or did you pay $4,000?
But wasn't that they had the ability to do that on cross in the deposition? Isn't that the same opportunity they would have had below?
It's an opportunity, but the interpretation from Homeowner's Choice wasn't put out into the world until this motion was filed. And so the interpretation that Synergy had, we think is the reasonable one, but developing that further is something really that the carrier should have done, because they have the burden of proving by clear and convincing evidence all the elements of fraud on the court. And if there's some ambiguity here, if there is a question here and you have to extrapolate meaning from testimony, then that's not clear and convincing evidence, or at least it should be resolved before the case is completely done away with without a jury able to resolve it.
Okay.
But if there's no further questions, I'll reserve the rest of my time.
Okay, you've got 3.5 minutes when you come back.
Thank you.
Okay, thank you, sir. Mr. Tinker, I'd like to just go ahead and ask you a question right out of the box, because we all know you. You're in front of this court all the time. You're Mark Tinker and you represent the appellant. So I've made your introduction for you, but I want to ask the question that's just burning for me to ask. Cox versus Burke, a case you well know and both of you have read and cited in your briefs. It says when reviewing a case for fraud, the court should consider the proper mix of factors and carefully balance a policy favoring adjudication on the merits with competing policies to maintain the integrity of the judicial system. Because dismissal sounds the death knell of the lawsuit, courts must reserve such strong medicine for instances where the defaulting party's misconduct is correspondingly egregious. This does not look like this type of case. And you knew I was going to say that to you. So go ahead and try to persuade me otherwise. It just doesn't look like this kind of case.
Well, Your Honor, the fraud in this case that Judge Ramsberger found relates to the central issue in the case, which is obviously the main concern is, does it go to the heart of the case? They are asking for payment of these bills. The issue relates to the fact that these bills are themselves fraudulent, that they did not do the work, or that the work has already been paid for. And as you mentioned at the very beginning of the argument, to the extent that the entirety of the work has already been paid for, their entire estimate is $33,000. They've already received $33,000 worth of payment, whether it was paid by Mr. McGinnity himself or from Homeowner's Choice. So what he was looking at, and as far as whether this is sanctionable fraud or something sufficient to require dismissal, is the repeated nature of it and the fact that they've stuck with these demands despite there was the original interrogatories that were mentioned where they said, here's our estimates. Then we go and take the deposition of Mr. McGinnity, and his testimony was very clear about some things that weren't done. I know there's been some argument that, kind of hedging about things, but when you talk about, on the estimates, there's a line items for replacing the laminate wood floors, and there are no laminate wood floors in that house because Mr. McGinnity said, I put tile in. I mean, there's no laminate to be found. There's issues with painting the entire living room. When he said they didn't even go in that living room, they would have no reason to. It was a kitchen pipe leak. None of these things were done. entire kitchen countertops that he said they did not replace. I hired a third party to come in and, I paid for the countertops and had a third party come in and do those, but they're still on these invoices. So they put all of those in initially. The testimony came in where they were present at Mr. McGinnity's deposition. Synergy had the ability to cross-examine him, to ask him questions. Their cross-examination only lasts barely 7 pages, and they don't even address any of the things that he just got done saying about all these things that they didn't do. And then after the deposition, new discovery was sent out asking them to say, okay, now that we've had this testimony, are your estimates your final demand? Is that what you're seeking? And they say yes. It was done through a request for admissions. They say admitted. That is what we're seeking. And then they're asked, are there line items on there that you perhaps didn't do? Or are there line items on there that the homeowner paid for? And they denied all of those. They were sticking to their guns saying, we want this paid in full. Yes, this is our full estimate. No, there is nothing on there that, either we didn't do or that the homeowner paid for. So I think that is where it crosses the line into something that is sanctionable. And I think Judge Ramsberger certainly thought so, because at the end of this hearing, on this record, we don't know the outcome of it. He was considering 57-105 sanctions, saying this entire lawsuit is a fraud. This entire lawsuit it's a sham, pleading sham litigation, because you are asking for payment of things that you did not do, or that the homeowner already paid for himself, and you're asking for reimbursement for them again. So under the Cox precedent, goes to the heart of the case, did Judge Ramsberger have the ability to examine everything and decide if it was an intentional, subversive use of the court system to obtain their means? Yes, they maintained this is what we are demanding that you pay us, even though now we have testimony out there saying you didn't do these things. And anything other than that, as far as there was the argument today about an evidentiary hearing or anything else of the sort, there are two things. Obviously there was no request for an evidentiary hearing. There was no response filed. Judge Ramsberger mentioned that response as far as evidence. He said there's no affidavits being filed by Synergy. The argument was made today that, well, you didn't take any testimony from Synergy. We don't have to. They didn't file any affidavits. They didn't say, here's what that testimony would have showed that would have, made an issue here for the court to consider. And they had the ability to cross-examine Mr. McGinnity when he testified. Again, they didn't ask anything about any of these matters. They were discussing, issues about mold or something that was found in the house. So they, kind of got sidetracked with that. So when it comes down to it, we're looking at, did Judge Ramsberger abuse his discretion when he decided that this entire lawsuit is a sham, that is deserving of the sanction of dismissal? And there's nothing in the record that says otherwise, because they didn't file any proper opposition to it.
Mr. Tinker, are there any cases finding, fraud on the court where the plaintiff, there is no sworn testimony from the plaintiff?
Not that I'm aware of, but I think this is different because this is an assignment case. So really, Synergy is an assignment of Mr. McGinnity. So there is sworn testimony from the insured, from essentially the plaintiff.
Sure, but we can't impute if the trial court has to find an unconscionable scheme. That's not found from the plaintiffs. The owner's testimony. Are you saying we can impute that testimony to Synergy to find the unconscionable behavior?
Well, the unconscionable behavior by Synergy is in their discovery responses that they did file, where they said, these are our bills, these are our estimates, that's what we want paid. And then there was the deposition of Mr. McGinnity, and then a follow-up discovery saying, is that, now that we've heard this, is that your full bill? You want all of that paid? And they filed, discovery responses saying, yes, that is, in the form of admissions, and then asked if any of those line items were incorrect. And they said, no, they weren't, denied all of those things. So that is the evidence coming directly from them, where we have this testimony now from the one person who would know, that if Mr. McGinnity walks in his house, he knows if those are new floors or not. He knows if those are new cabinets. He knows whether or not they painted the living room. And he said, no, they didn't do those things. I did them.
And without the benefit of an evidentiary hearing, do we not give less deference to the trial court's findings here, because they have the trial court has the same thing that we're reviewing?
Yes and no. The way you worded that, without the
Okay,
benefit of
help
an
me, help
evidentiary
me.
hearing, that you know, I understand that we're under an abuse of discretion standard, but I understand that it's you know, considered a lessened standard. I don't know how we put tiers on these things. But I understand if, you know, that he had an evidentiary hearing and heard live testimony and he looked at someone and said, I don't believe you, you're lying to me. Obviously, we'd have to give deference to that if we're just looking at a transcript of the hearing. None of that occurred. So you have the same documents he had, but at the same time, he had the ability to look at the lawsuit as a whole and see the course of proceedings. And what I said, I didn't like the way you worded it, is you said, well, without an evidentiary hearing, what does that do? Well, I don't think that can come into account here because none was requested of him. So even though it is still an abuse of discretion standard, now what Synergy is asking you to do is to find that he abused his discretion by not holding an evidentiary hearing when they never asked him to do that. So they never requested one. They never filed any affidavits. They never filed any competing evidence. They waited until literally the eve of the hearing to even file a written opposition, which Judge Ransberger said he didn't even have in front of him. So he asked at the conclusion of the argument, understanding that I haven't seen what you filed, have you told me everything that I need to know? And Synergy's counsel said yes. So they told him, this is everything you need to know. We agree. You mentioned it earlier, Judge Smith. You know, we understand what Mr. McGinnity testified to, and we don't oppose anything he said. You know, we agree that that's what he said. So they didn't object to anything. They didn't ask for any lesser sanctions. They didn't say, strike all of these improper issues from our you know, estimates and don't let us present evidence at trial. They didn't ask for that. They didn't ask for anything. They just tried to say, well, because Mr. McGinnity isn't licensed and because he wasn't always there, maybe he doesn't know. And there was argument that was made here today, kind of along the same vein, saying, well, you know, if we look at the way that the accounting works and you look at what he pays for and who's entitled to what, and I heard the math coming into it, trying to say that some of these things might not be false, when some things, I mean, there's no arguing around the fact that, like I said, the hardwood floors or the laminate wood floors that do not exist. It's tile in there. And Mr. McGinnity said, I paid for it and I had it installed. So, you know, there's no way to get around some of these things. But going back to what I was saying, you know, what they're asking you to do is to find, well, Judge Ransberger should have considered more. He should have gotten sworn testimony from Synergy. He should have had an evidentiary hearing. Synergy never asked for any of those things. At the conclusion of the hearing, they said, we presented everything we want you to consider. They didn't ask for anything less. They just said, no, we don't want this case dismissed because we think that because Mr. McGinnity isn't licensed, or he's not a contractor, he wasn't always there, he might not be sure what he's talking about, and asked the judge, to consider it on that. And I mean, Judge Ransberger understandably said, I don't think that's plausible, for someone to not know if their countertops have been replaced or not. I mean, you don't need to be a licensed contractor to know that. You walk into your kitchen, I can tell you if my countertops are the same ones that were there when I left this morning. You know if that's been done. So to ask the court to find an abuse of discretion and reverse based upon any of those factors, I think would be inappropriate at this point because they never asked for them. I hope that answers your question. I didn't have any other notes other than that. Let me just double check. And that is all. Those are all the notes I made, unless the court has any other questions. And thank you for your time this morning.
Thank you, sir.
Thank you.
Mr. Herman, you have 3.5 minutes, sir.
Thank you. So first, I want to talk about this tile versus laminate. The tile was an upgrade. No one on this insurance claim would be entitled to be paid for tile when there was laminate before. But the fact that it was upgraded does not mean that Homeowner's Choice doesn't have to pay for the original laminate that was there, and that was in the estimate. If Synergy had written an estimate that included all these upgrades and said, pay us for all of it, this would be fraud in the court, because they would be saying, pay us for stuff that wasn't ever there. And that's not what happened here. And there was a suggestion that Mr. McGinnity is the best source of evidence here. And despite, what I said about his, memory and not being a contractor, that's just not the case at all anyway, because he's just a person. We've got the fraud in the court cases where things are affirmed. You've got usually medical records. You've got actual concrete evidence that you can't question. And here, there could have been concrete evidence that the carrier developed. For instance, they could have done a property inspection and compared the photos that their adjuster took right after the loss to what's there now. What's different? And provide the court with actual things that can't be questioned. But I think the really big point here, though, that makes his case so different and one that should be reversed is that none of us on both sides of the V in this case could find any case like this where you just have written discovery and no testimony, either in evidentiary hearing or in deposition, where the court has affirmed a dismissal for fraud in the court. And then when you compare it to cases where this court has reversed, you have so much less evidence here. So for instance, in the Jacob versus Henderson case, which was decided in 2003, in that case, there is surveillance video of a plaintiff who is sweeping her driveway and closing doors. She then testifies, this is a personal injury case, she testifies, I can't open doors, I can't sweep. Obviously, those go to the heart of the case because those are part of non-economic damages in a personal injury case. This court reversed, and they did so saying that can be dealt with through impeachment. Yes, it's a lie. We understand why the trial court got mad, but reversed because it can be dealt with through impeachment, just like it can here. If there's inconsistencies, put the homeowner on the stand at trial, impeach Synergy. The same thing in Duarte, which this court reversed in 2017. In that case, you had interrogatories where a subsequent accident is not disclosed. You say, I don't remember. A 2-day deposition of a plaintiff. And the plaintiff in that case is downplaying a car crash, a subsequent car crash, which goes into, again, damages, and saying, I wouldn't even consider it an accident. There was barely any damage, a few dollars to my headlights. Then in the EUO of the accident, where he's seeking money in that case, he testifies, it's a hard hit, it's an accident, it caused a lot of damage. And you've got competing testimony from the very same person, both sworn. And again, this court reversed the dismissal for fraud in the court, said, yeah, those are lies, those are consistencies, but you can deal with it on impeachment because that is an available remedy. It's the remedy here, just like if these requests for admissions truly are not correct, they can be addressed as well through the sanction afforded by Rule 1.370 or 1.380, not through dismissal. And that sanction is attorney's fees. Am I at my time?
You're right at it. You nailed it.
I thought so. Well, we asked you reverse, and thank you.
Okay. Thank you both. It's a very interesting case, and you briefed it well, both of you. You made it very interesting for us to sort of analyze this issue. So thanks so much for your hard work. Have a good day.
Thank you.
Our next case is Goodwin versus Michelini. Okay. Mr. Barak?